Assalamualaikum warahmatullahi wabarakatuh. Today I will present a presentation titled The Objectives of Research and its Contribution to Society and Community. First, I will introduce what is the research. Research is an academic discipline which requires a strong academic foundation. Research requires the ability to define, describe, and explain what the topic is, to what extent the discussion is, and how the question is answered. So, in our class, I will focus more on legal research, where we are law students. So, in general, the research discussion is very wide. So, I want to quote one of the academicians named Julius von Cushman, which claimed that the sun, moon, and stars shine like centuries ago, and rose is blossoming like in paradise. However, law is different. It is like a wanderer in the desert. 3 words changed by the lawmaker may render entire library useless. So this is where my presentation will focus in. I will focus the presentation today about the legal research and its objectives, and also its contribution to society and community. Legal research is a systematic way to identify the sources of law applicable to understand a legal problem, develop legal questions, and then find a solution to the problem that has been identified. It has many differences, wide differences compared to general research or another field types of research such as scientific research, economic research, or other different angle. And in legal research, there are many terms and also names which famously claim in legal scholarship. The one of it is black letter scholarship research, which black letter law research aims to systematize, rectify, and clarify the law on any particular topic by a distinctive mode of analysis of authoritative texts that consists of primary and secondary sources. One of its assumptions is that the character of legal scholarship is derived from the law itself. So we can understand now that the legal research by the name of black letter law is the research focused purely on the law and the case law, which not involve another elements of social, economic, and scientific fields of research. Next, what are the objectives of research in general? In general, there are many objectives of research that has been enlisted by academicians and scholars. We can understand that research, the objective of it is to discover new facts and verify all facts, to analyze the facts in the new theoretical framework, to examine the consequences of new facts or new principle of law, to develop new legal research tools of other disciplines in the area of law, to propound new legal concepts, to ascertain the merits and demerits of all law or institution, to develop the principles of interpretation for critical examination of statutes. This is a very, very general objectives of legal research itself. Next, based on the Davis states he underlined some objectives of black letter law legal research. For black letter law legal research, the objective is to determine the objectives of the lawyer or client, to identify and analyze factual material, to identify the legal context in which factual issues arise, to identify sources for investigating relevant facts, to determine when further facts are required, to identify and analyze legal issues, to apply relevant legal provisions to fact, to relate the central legal and factual issues to each other, to identify the legal, factual, and other issues presented by documents, to analyze a client instruction and be able to identify legal, factual, and other issues presented to them, to present the results of research in a clear, useful, and reliable form. So, between these objectives with the legal research previously presented by me, it clearly understood that David Stokes clarified and identified more deeper objectives for black letter law or doctrinal legal research. Next, I will present two types of legal research which we can understand clearly in terms of its division or categories. The first category of research objectives is doctrinal research objectives. Doctrinal research is a pure law research. The doctrinal research objective is to describe the existing law, the lex lata in certain field or concerning a certain institution in a way that is as neutral and consistent as possible in order to inform the audience how the law is actually read. Next, description is always complemented by a more prescriptive approach directed towards legal decision makers such as legislatures and courts, and to a lesser extent the executive. There is a very good reason why legal doctrine can fulfill this role. To establish the lex ferenda, it reflects the law normativity. The third objective of legal doctrine is the justification for the existing law. Here, the essence of the internal perspective comes out best. If the law is presented as a self-contained system or mutual reference, the validity of norms can be justified by reference to this system. Next, non-doctrinal research objectives. Non-doctrinal research represent new perspective or understanding law in the modern social and political context, with the use of a range of other methods taken from disciplines in the social sciences and humanities. The specific objectives of non-doctrinal research is to conduct research with the discipline of social sciences. The merits and relevance of using other disciplines such as sociology, political science, economics, psychology, history, and feminism as aids to legal research has been widely recognized. Furthermore, non-doctrinal research employs a wide range of applied social science methods including quantitative and qualitative research. These methods aim to harmonize the workings of legal, social, and cultural processes while conducting a study. The another part of my presentation is the contribution of research to society and community. The first contribution is well known to legal practitioners, of course, where legal research is a very important tool for practicing lawyers and law firms. The findings from legal research is important in giving the information of the leading case governing the issues in question. Next, the contribution to the judicial institution and government. There are challenges in administering laws and governance in a country where the judicial organs continuously face changes in laws from time to time. Evolving community trends of social development also make it difficult for government to enact the current law, and it needs to be reformed if required. So, from the legal research, it will help the government to make the next progress. Finally, the contribution to academics and public. A legal research paper is one of the materials that can help the academicians to develop legal knowledge. Through knowledge from the legal research, it will help law scholars in determining the law on significant issues and facts. Legal research can help academicians to develop a new theory in law, reinterpretation of existing law, and propose the best solutions in solving issues in society. Thus, it will be referred as an important academic writing for lawyers, judges, and others. As conclusion, both doctrinal and non-doctrinal legal research are important for the society and community. A good legal research, which has been carefully conducted with full supervision from legal experts, will benefit not only the personnels and legal profession, thus it will help the nation to reform the laws and protect its sovereignty with the best advice from the legal experts themselves. Furthermore, the legal research will bring positive impact on the development of law not only inside the country, but to the international level of legal scholarship. That's all my presentation today, and I wish thank you for your time, and I wish safety and stay home, stay strong to all my friends. Assalamualaikum warahmatullahi wabarakatuh.